Hello, everybody. Welcome to the Constitution of the United States by the History Lecture. All right, we're going to start our lesson with the Articles of Confederation. The Articles of Confederation were the colony's first attempt at government, but this document gave very little power to the federal government. They weren't even able to raise an army, levy taxes, and there was no executive branch. There was only legislation with only one body, and each state had one vote. Because of those reasons, many thought it needed to be modified, including James Madison and Alexander Hamilton. As we said, there was only one branch of government, the legislature. One thing they did do good, though, was they negotiated the end of the war with the Treaty of Paris. The beginnings of the Constitutional Convention. So at first, a convention was held at Annapolis, Maryland. People such as James Madison over here and Alexander over here were in attendance. But since only 5 states sent representatives, what happened was they petitioned the Congress to set a date for a convention in Philadelphia. And that was when the Constitutional Convention began. It began on May 23, 1787, and ended in September. 55 delegates from 12 states were selected. Among these, Thomas Jefferson and John Adams were away in Europe, so they were not at the convention, and Rhode Island did not attend. The convention was held in the Philadelphia State House in Pennsylvania. George Washington over here and over here, our first president, was the president, and William Jackson was the secretary of the convention. The first plan that was proposed by Mr. Edmund Randolph here was the Virginia Plan. This divided the government into 3 branches. In this, the legislative branch was divided into 2 separate chambers. The lower chamber was elected by the people for 3 years, directly, but the upper chamber was elected for 7-year terms by the lower chamber. The number of representatives for each state was determined by population, which led to a lot of objections from small states. Debating the Virginia Plan. A committee was headed by Governor Morris of Pennsylvania over here to decide on what the Virginia Plan's final draft would be. There it was agreed upon that there would in fact be 3 branches and there would only be 1 president, because originally they wanted to have multiple, possibly, but it was soon pointed out that it would not give the one head of state too much power because states had governors. So that argument was pretty much set aside after that. And a head court would oversee small courts. Now here, I am actually going to read the final resolution of the Virginia Plan. This was not the final constitution, but the final version of the Virginia Plan that would be put forward. 1. Resolved, that it is the opinion of this committee that a national government ought to be established consisting of a supreme legislative, judiciary, and executive. In simpler terms, there would be 3 branches. A legislative branch, Congress, the judiciary branch, or, courts, and the executive, what would later become the president and the cabinet. Resolved, that the national legislature ought to consist of 2 branches. This means that the legislative branch would be divided into the 2 chambers that you heard about in our first slide. 3. Resolved, that the members of the first branch by the national legislature ought to be elected by the people of the several states for the terms of 3 years, to receive fixed stipends by which they may be compensated for the devotion of their time to public service, to be paid out of the national treasury. I'm going to stop there in this one. That basically says the people of the first chamber would be elected for 3-year terms by the people, and they'd be given a set salary that would be paid by the treasury for their service in the government. To be ineligible to any office established by a particular state or under the authority of the United States, except those peculiarly belonging to the functions of the first branch during the term of service and under the national government for a space of 1 year after its expiration. Resolved, that the members of the second branch of the national legislature ought to be chosen by the individual legislators, to be the age of 30 years at least, to hold their office for a term sufficient to ensure their independence, namely 7 years. Now, the reason it says this is because when the Virginia plan was first put forward, it was not a definite plan. It was, here, this is an idea, let's build upon it. It was 15 amendments, and they left blanks for term limits and how old you had to be. So they did not present it to be, they presented it to be changed a little bit. All right. To receive fixed stipends by which they may be compensated for the devotion of their time to public service, to be paid out by the national treasury, to be ineligible to any office established by a particular state or under the authority of the United States. Yeah, it's the same thing as the first one, basically. You get money, and if you're not deemed to serve, you can't serve. Resolved that each branch ought to possess the right of originating acts. Basically, the branches would be separated. 6. Resolved that the national legislature ought to be empowered to enjoy the legislative rights vested in Congress by the Confederation, and moreover to legislate in all cases to which separate states are incompetent, or in which the harmony of the United States may be interrupted by the exercise of individual legislation, to negative all laws passed by the several states contravening in the opinion of the national legislature, the articles of union or any other treaties subsisting under the authority of the union. Basically, federal law was supreme above state law. If there was state law that didn't line up with federal law or got in the way of unity between the states, it would be stricken down and federal law would be put in its place. 7. Resolved that the right of suffrage in the first branch of the national legislature ought not to be according to the rule established in the Articles of Confederation, but according to some equitable ratio of representation, namely in proportion to the whole number of white and other free citizens and inhabitants of every age, sex, and condition, including those bound to servitude for a term of years, and 3/5 of all other persons not comprehended in the foregoing description, except Indians not paying taxes in each state. Basically, population would decide how much representation you got. And it includes some of the 3/5 compromise. 8. Resolved that the right of suffrage in the second branch of the national legislature ought to be according to the rule established for the first. Basically, suffrage means voting, like your voting rights. So, basically, 8, the same thing in the second branch of the legislature. They're the same thing. Yeah, just restated in the second branch. 9. Resolved that a national executive be instituted to consist of a single person to be chosen by the national legislature for the term of 7 years, with power to carry into execution the national law, to appoint to offices in case not otherwise provided for, to be ineligible a second time, and to be removable on impeachment and conviction of malpractice or neglect of duty, to receive a fixed stipend by which he may be compensated for the devotion of his time to public service, to be paid out to the national treasury. Basically, the chief executive, the president, would be one person to serve for one term of 7 years. They would not be able to run again, and they could be impeached. Their powers were, they had to execute the laws and appoint people in office once the offices were vacant. They would be paid money from the treasury. 10. Resolved that the national executive shall not a right to negate any legislative act which shall not be afterwards passed unless by 2/3 of each branch of the national legislature. A lot how it works. The president got a veto and could pass a law, but if 2/3 of the people of each branch wanted the law to then be passed, the veto would be overruled. 11. Resolved that a national judiciary be established to consist of one supreme tribunal, the judges of which to be appointed by the second branch of the national legislature, to hold their offices during good behavior, to receive punctually at stated times a fixed compensation for their services, in which no increase or diminution shall be made, so as to affect the persons actually in office at the time of such increase or diminution. Basically, there would be a Supreme Court. The judges would be selected by the states. 12. Resolved that the national legislature be empowered to appoint inferior tribunals. Basically, the highest judge could appoint judges that are below them. 13. Resolved that the jurisdiction of the national judiciary shall extend to cases which respect the collection of national revenue, impeachment of any national offices, and question which involve the nation's peace and harmony. I don't think I need to explain that one. That's just saying what the judiciary can do, what crimes they could charge people with. 14. Resolved that the provision ought to be made for the admission of states lawfully arising within the limits of the United States, whether from a voluntary junction of government and territory or otherwise, with the consent of a number of voices in the national legislature less than a whole. Oh, sorry, microphone cut out. 15. Resolved. The provisions ought to be made for the continuance of Congress and their authority until a given day after the reforms of the Articles of Union shall be adopted, and for the completion of all their engagements. Basically, the Congress would continue until the new laws were enacted. 16. That a Republican Constitution and existing laws ought to be guaranteed to each state by the United States. States could somewhat govern themselves. 17. The provision ought to be made for the amendment of the Articles of Union whensoever it shall seem necessary. They could amend the articles when they needed to. 18. Resolved that the legislative, executive, and judiciary powers within the several states ought to be bound by oath to support the Articles of the Union. They would be sworn in, basically, and they had to promise to execute the laws. 19. Resolved that the amendments which shall be offered to the Confederation by the Convention ought at a proper time or times after the appropriation of Congress to be submitted to an assembly or assemblies of representatives recommended by several legislatures to be expressly chosen by the people to consider and decide thereon. There would basically, that said, laws would go to committee. Proposed amendments. All right, that was a long one. That's definitely going to be the longest of the slides, even. I didn't expect it to be that long. But anyway, moving on to the New Jersey Plan. This was proposed by William Patterson of New Jersey. Unlike the Virginia Plan, this was not proposed as an entirely new form of government, an entirely new document. This was proposed to as additions to the Articles of Federation. This also had 3 branches of government, and it had I misspoke here, a unicameral legislative branch with all states represented equally. There would only be one body in the legislative branch, and all states would have one vote, like they did in the Articles of Confederation. Multiple executives in the executive branch. Instead of having just one president, it would be like a committee where there were multiple presidents. And the judicial branch's judge had little power and were appointed by the executive branch. Basically what I said there. Let's move on. Debating the New Jersey Plan. The large states, population-wise, like Massachusetts, Pennsylvania, Virginia, opposed it because they believed they should have more representation. They have more people than, people of New Jersey and Rhode Island, and they knew that, there was going to be expanding out west, and that they will have small populations, but they would still get the same amount of representation as them. So they did not like it and strongly opposed it. The small states liked it because it gave them say in the government. They felt if it was based on population, that Rhode Island's opinion or, New Jersey's, it wouldn't matter because the large states would just overpower them. But the New Jersey Plan was eventually voted out on June 10th. Didn't make it to committee. Should be a capital J, but... All right, now there's one more plan here we'll discuss, which is Alexander Hamilton's plan. This wasn't really an official plan. He did put it out there, but it was never voted on. Basically, there was 3 branches. The legislative branch was divided into 2 parts. Shouldn't have an apostrophe there. Kind of like James Madison's plan, or the Virginia plan with James Madison and Edmund Randolph, where there would be a lower house that would be elected by the people and an upper house chamber that would be elected by the lower chamber. But in this plan, the upper chamber would be able to serve as long as they wanted. And there was an executive branch headed by a governor who served for life. The governor would have a lot of power. The head of state, they would be able to appoint whoever they wanted to the three main positions: foreign affairs, defense, and treasury. It didn't have to be approved by Congress. They got a veto like they do now, but also they didn't have to enforce laws that they didn't want to. They basically had diplomatic freedom and basically only had to send treaties to be approved by Congress, and they were commander-in-chief of the military. So kind of similar to what we have today, except the executive branch was much more powerful. Also, judges, they served for life. Judges would have to be approved by the legislative branch. But he didn't believe, I'm going to go back there to his plan. He didn't believe that this would be tyrannical because the executive, the governor, could be impeached. So he believed that as long as you could impeach a ruler, it wouldn't be tyranny. All right, now we're going to talk about the Connecticut Compromise. This over here is Roger Sherman, who is given most of the credit for coming up with this compromise. But a lot of delegates from the state of Connecticut worked on this compromise. The compromise said there would be 3 branches, just like all the other plans, and the legislative would be divided into 2 chambers, like there were in Hamilton's plan and the Virginia plan. They'd be divided into a Senate and House of Representatives. The Senate would be chosen by equal representation. There would be 2 for every state. That's still how it is today. The House of Representatives, it would be determined based on population. And there would be a chief magistrate, which would eventually become a president to lead the country at the head of the executive branch. There'd be a judicial branch with a Supreme Court that would be able to create inferior courts, etc. All right. The question of slavery. This here is Ben Franklin, who was an abolitionist and opposed slavery. The delegates debated that if slaves should be counted as people and if slaves should be abolished altogether. They knew that if they counted slaves as people, then the representation of the South in the House would skyrocket because they had the most slaves of any of the regions. And people were saying, we've created a free government, we should free all people. But eventually a few compromises were reached. The 3/5 compromise, which said that slaves and other unfreed people would count as 3/5 of a person towards the population. So for every 10 slaves, 6 would count as people. And they also agreed that the slave trade would finally be abolished in 1820, which is very different from freeing the slaves. They couldn't import new slaves. Ratification. At first, a vote was taken and a tie of 5-5 was reached because New York went home and Georgia was tied, and obviously Rhode Island didn't attend. But eventually, 9 out of the 13 states ratified the Constitution, and under this, George Washington was sworn in as our first president. This will be the topic of our next video. In our next series of videos, we'll cover the presidents. I kind of wanted to start with this because, it gives you background on the convention. And I also made this. Now, I excluded the judiciary branch because I couldn't figure out how to make 3 branches, so I just went with this. So, you have the government. Also, there should be, again, as I mentioned, there should be a judicial branch here. But anyway, we'll go with what's there. There was the legislative branch that was divided, of course, into the House of Representatives and the Senate. And there was also presidents. There was the President of the United States. He had his vice president under him who would, if he died, take over. The first vice president would be John Adams, and the first president would obviously be George Washington. And then there was his cabinet. Now, the Constitution never said there had to be a cabinet. George Washington created it because he knew he needed advisors to help him run the country. At first, there were only three: Secretary of War, what is now Secretary of Defense, Secretary of the Treasury, and Secretary of State. The first leader of Secretary of War was Henry Knox. Secretary of State, Thomas Jefferson, and, of course, Secretary of the Treasury, Alexander Hamilton. And that is it, everybody. Thank you for paying attention, and we'll see you next video.